Joran Van Sloot is in the United States, sitting in a jail less than 10 miles from where Natalie Holloway's childhood home is. He's the prime suspect in her May 30, 2005 disappearance, and on Friday in a federal court in Birmingham, Alabama, Van Sloot pleaded not guilty to 2 felonies, extortion and wire fraud. The charges involve allegations that he tried to extort and defraud Natalie Holloway's mother, Beth. On Friday in the courtroom, Van Sloot was about 8 feet from Beth Holloway, but he did not turn around and look at her. Former U.S. Attorney for the Northern District of Alabama, Jay Town, joins me. Nice to see you, Jay. And Jay, now that Joran Van Sloot has been arraigned and discovery begins, what's the information that the prosecution must turn over to Joran Van Sloot's lawyer?
Well, all the information that's contained in the 4 corners of the indictment, that'll all be turned over, and the proofs that support what's alleged in the indictment. So any videos, anything that was written down by the FBI taking notes as they were talking to Joran, or videotaping and witnessing him. Any interviews with Beth Holloway about what she perceived when she had discussions, and John Q. Kelly as well, and any exculpable evidence. Whatever hellhole he's been in Peru for the last 12, 13 years, he's in America now. You see on social media where people hope that he's in a bad place here in the United States. No, he's in American jail. He's going to be protected. It's the United States' duty to protect him while he is here. And the marshals will live up to that duty. And so he's also going to get a fair trial. He's going to be able to take advantage of rights that he's never had and under the 4th, 5th, 6th, and 8th Amendments. But he's also going to get every ounce, every minute, every mile of justice that's coming to him.
Well, it's important that he has a fair trial, because if he is convicted and it goes up to the Court of Appeals, obviously you want the trial to be a solid one and one that's not going to be reversed on appeal. All right. One thing that struck me as odd, I was in the courtroom, is that there was no discussion of speedy trial. I'm accustomed to you plead not guilty and you either waive your speedy trial or you invoke your speedy trial. There was no discussion of speedy trial.
Well, it is not atypical. So for your viewers, the federal government is under a duty under the Speedy Trial Act to bring every case it indicts to trial within 70 days, unless that speedy trial right is waived by the defendant, which oftentimes happens if a case is complex. But in this particular case, these charges are not particularly complex. It might be that the defense counsel asks for a continuance. It'll be a short continuance. It won't be years. It'll be a few months. It really just depends on the volume of discovery. So I think the presumption is that sometime in August, this case will be brought to trial unless Joran Van Sloot and his counsel decide otherwise. And a judge would still have to sign off on it. It can't be for no reason. There has to be a good reason to waive that Speedy Trial Act. And those milestones, those trial milestones, and motions that need to be filed by the defense and the United States, those will all come before that. So to lay out that calendar, they have to have a trial date. But I would suspect Joran Van Sloot is going to be tried. I suspect he'll be convicted also. And sentenced all in 2023.
He has a federal defender appointed. He can hire his own lawyer if he wants. But frankly, and I always say this to anybody, if you can get a federal defender, take it, because they're usually the lawyers day in and day out who try these cases. Sure. They know so much more than a lawyer might retain. So I'd much rather have a federal defender than go out and hire one, not to mention the money.
Well, the public defenders also, they work with the prosecutors a great deal. So this discovery is seamless. They know the judge. They've appeared in front of the trial judge, dozens, if not hundreds of times, depending on the experience of the PD. So it is, in some ways, it's an advantage because they're so familiar with the federal system and the rules in that particular courtroom. But the prosecution has the same advantage. They are in front of that judge more often than any of the public defenders. So, but it's good that they're working together.
I'd rather, if I were a defendant, I'm going to take the last one. If I were a defendant, I'd rather have a lawyer who day in and day out tries criminal cases than the one who's in a big law firm who occasionally comes in to try a case and doesn't have that day-to-day experience. But anyway, taking the last word on. Jay Town, thank you.
Thank you, Greta.